Okay, we proceed further with the test preparation, and we proceed with constitutional provisions for the protection of environment in India. So, Indian Constitution provides for a special provision for environment protection. The High Courts and Supreme Courts in India has given a wide interpretation to the constitutional provision of Article 21 of the Constitution. So, wide interpretation of Article 21. The relationship between man and his environment is undergoing profound changes in the wake of modern scientific and technological developments. As India is signatory to the Stockholm Declaration, which provided to defend and improve the human environment for present and future generations, which has become imperative goal for mankind. So India is a signatory to the Stockholm Declaration, and Stockholm Declaration stated that and Stockholm Declaration was made with the aim to defend and improve the human environment. Defend and improve the human environment for present as well as for future generations. For present as well as future generations, and it has become an imperative goal for the mankind. Okay. Accordingly, Indian Constitution was amended in 1976 to incorporate the provisions for protection of environment and imposing fundamental duties upon citizens of this country to protect and improve the natural environment. So, amendment in 1976, and this amendment imposed fundamental duties upon the citizen of the country to protect and improve the natural environment. So, fundamental duties of protecting and improving the natural environment came as a result of the amendment of the Indian Constitution in the year 1976. In addition to these amended provisions, the Constitution of India contains, in addition to these amended provisions, the Constitution of India contains some other provisions which if not directly, then indirectly provides for environmental protection. So, directive principles of state policy. This is a part in the Indian Constitution, and in that part of directive principles of state policy, there are some relevant provisions which directly or indirectly related, which directly or indirectly relates to environmental protection under the Constitution of India. Under the Constitution of India, and that you'll find the directive principles of state policy in part 4 of the Indian Constitution. Okay, in part 4 of the Indian Constitution. All of this is just garbage. This is not needed. Okay. Okay. So some relevant provisions which directly or indirectly relating. God, what am I doing? It always pesters me when I find grammatical mistakes. Okay. Anyway, some relevant provisions which directly or indirectly directly or indirectly relating to environmental protection under the Constitution of India. Good Lord, whatever is written. Some relevant provisions exists directly or indirectly relating to the environmental protection under the Constitution of India under Part 4 Directive Principles of State Policy. Okay, please do not refer to this particular part. I don't know what garbage has been spewed here, but then anyway. Though these principles are not enforceable but are fundamental in governance of this country, and it shall be the duty of the state to apply them in making laws. Okay, so it is not enforceable, they are just directives to the states. Therefore, it's not enforceable, but the state shall have to abide by it and apply. Like, state shall have to endeavor in making laws in favor of the directive principles. Anyway, so those articles are now being read. These are Article 39 and Article 42, Article 47, Article 48, and Article 48A, Article 49, and that's it. So these are the articles under the Directive Principles of State Policy, which talks about the um, environment protection. Okay. So Article 39 of the Constitution envisages that the distribution and management of material resources, which includes natural and man-made resources, in such a manner that their concentration and monopoly over their use should not give rise to ecological imbalance and health hazards. So this is about distribution of natural resources or man-made resources. Article 19 is about distribution of the Constitution, and we say that the distribution and management. Okay, so distribution and management is also there. Distribution and management of material resources, which includes natural and man-made resources, in such a manner that their concentration and monopoly over their use should not give rise to ecological imbalance and health hazards. Should not give rise to ecological imbalance and health hazards. Okay, Article 39. Now we talk about Article 42. Article 42 of the Constitution empowers the state to make provision for securing just and humane condition of work and maternity relief. Make provisions for securing just and humane condition of work. Just and humane condition of work. Under this article, state is directed to secure just and humane condition of work which can be achieved in clean environment. So that's how they relate. Just and humane condition of work possible only if there is a clean environment. Article 42. Next is Article 47. So we did with 39. We talked about distribution and management of material resources so as not to have monopoly and not to give in such a manner that their concentration and monopoly over their use should not give rise to prevent monopoly, and even if the monopoly and their concentration should not result into the ecological imbalance and health hazards in Article 39. And Article 42 is about just and humane working conditions. So that's possible only if you have a clean environment. Okay, so moving on. Article 47. Article 47 of the Constitution provides that the state shall regard the raising of the level of nutrition and the improvement of public health as among its primary duties. So the state shall regard the raising of the level of nutrition, and improvement of public health as the primary duty, among the primary duties. Okay, so there are some primary duties of the state. Now these primary duties, among them the prime duties are raising of level of nutrition and the improvement of public health and the standard of living of its people, and in particular the state shall endeavor to bring about prohibition of the consumption except for medical purposes of intoxicating drinks and drugs which are injurious to health. So your toxins and all toxic is not pretty useful because well, the state, even though if it's a directive, the state has the power to prevent its use unless for the purposes of medical reasons or for medical reasons, except for medical purposes. It can be banned. Uh, Raising of level of nutrition and improvement of public health is what we have to think about, however. Okay, and also the standard of living also, but that in a sustainable development manner. Anyway, so under this article, the state is duty bound to improve the public health. So Article 47 is about improving the public health. This constitutional duty can be fulfilled only in an atmosphere of clean environment. That is the main gist of the thing. So if they say they have to raise the level of nutrition and improve the public health and raise the standard of living, then that can all happen only if there is a clean environment and there is sustainable development going on. Okay. uh Next is Article 48. So we did with Article 47, that's about public health improvement and all. Article 48 of the Constitution provides that the state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall in particular take steps for preserving and improving the breeds and prohibiting slaughter of cows and calves and the other milky and draught cattle. Other milch and draught cattle. Milky. Acha. Okay. Article 48 of the Constitution provides that the state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall in particular take steps for preserving and improving the breeds and prohibiting cow slaughter and calves and other milch and draught cattle. This article provides for security of cows, calves and other milch and draught cattle, which helps in maintaining ecological balance. Good lord, the connection. Anyway, so it's like protect the cows and calves and the draught cattle because it will maintain ecological balance. Okay, for the sake of ecological balance, prohibit the slaughter of cows. Good lord. Article 48. Okay. Article 48A. The state shall endeavor to protect. Only is the thing. And the cattle and other milch. And the other things are okay. But these are important. Okay. Article 48. Next is Article 48A. The state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of country. Very, very important. This is, I believe, the most important thing. Article 48A. Article 48A, it states that the state shall endeavor to protect and improve the environment. State shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. Safeguard the forest and wildlife of the country. Protect and improve the environment and safeguard the wildlife and forest of the country. Article 48A. Right, moving on. Article 49. Article 49 of the Constitution of India provides that it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest declared by or under law made by Parliament to be of national importance from spoliation, destruction, removal, disposal, or export, as the case may be. Monuments. Protection of monuments. Okay. So this article speaks about protection of monuments in places and objects of national importance, includes the protection from environmental pollution. Therefore, the state has to make efforts to improve the environment for protecting monuments in places and objects of national importance. I don't know how it... we are dealing with constitutional provision for protection of environment. So if we consider monuments as environment, no, monument doesn't. Okay. Okay, fine. Monument. Article 49. Well, you can say, I mean, if you want to protect the monuments that our country is proud of, like the Taj Mahal and other important monuments and all, you will have to be very careful with the environmental aspects. That's the best explanation that I can try to give. Okay, so you need to do a place of restaurant declared made by this pollution and as the case may be. State has to make efforts to improve the environment for protecting monuments and places of objects of national importance. Okay, so these are the um, directive principles of state. So we dealt with Article 39, which talks about distribution and management of material resources in order to in order that it does not create any ecological imbalance and health hazards. And then we talked about Article 42, which talks about the securing of just and humane condition of work, which is possible only if there is a clean environment. Then we talked about Article 47, in which we talked about the raising of the level of nutrition or improvement of public health. Okay, improvement of public health. And then we talked about Article 48, which is about prohibition of milch cattles and milch and draught cattles, only them, and which helps in the maintenance of ecological balance. That will create a that will maintain the ecological balance, of course. And then Article 48A, which talks about the protection and improvement of the environment in order to safeguard the forests and the wildlife of the country. Protect and improve the environment and to safeguard the forest and the wildlife of the country, Article 48A. And then Article 49 talks about the monuments in places and objects of importance, of national importance. So state shall make endeavors to protect them, which can only happen if certain enactments are made on certain industries which are responsible for the yellowing and deterioration of such nationally important places and objects, monuments, whatever. Okay, moving on. So those were the directive principles. Now we talk about the fundamental duties which are enshrined in the Constitution, and we are all bound to take care of. Okay, so Article 51A, it shall be duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. So Article 51A, it shall be the duty of every citizen of India. So fundamental duties. 51A clause G. 51A clause G, to protect and improve the natural environment. Protect and improve the natural environment, including we have forests, lakes, rivers, wildlife, and have compassion for living creatures. Forest, rivers, lakes, and wildlife, and to have compassion for living creatures. Protect and improve natural environment. Protect and improve natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Right. So there's a case, Goa Foundation versus State of Goa, and in this case it is stated that question for decision before the Bombay High Court was whether a society registered under the Registration of Societies Act has the locus standi to move to the court to prevent ecological degradation under Article 51A clause G to a citizen and What A clause G? Okay. 51A clause G. Right. It was let's just take a look at it, right? Article 51 AG. Okay. A clause G. 51A, right, okay. So it's like 51 guard. 51A. This is not within brackets. It is 51A clause G. Okay, so under 51A clause G to a citizen, and it also has a similar duty of protection and improvement to environment. What the hell? So the question was whether a society registered under Societies Act has the locus standi to move the court to prevent ecological degradation or not. I believe it was in the favor of the societies, and the court probably agreed with the fact that yes, they have the locus standi to move the court to prevent ecological degradation. Goa Foundation versus State of Goa. So it shall be the duty of every citizen of India to protect and improve the natural environment. And this is important. This is, I believe, the most important thing. L.K. Kulwal versus State of Rajasthan. In this case, court observed that we are real citizens of the country and should strive towards excellence in all spheres of undivided and collective activity, including protection of environment. So the court observed that we are the real citizens of the country and should strive towards excellence in all spheres of undivided and collective activity, including the protection of environment. So we should strive towards excellence in all spheres of undivided and collective activity, and that should include the protection of environment also. L.K. Kulwal versus State of Rajasthan. So is that it? I mean, okay, that's all that it was said. Like, we should strive towards the protection of environment. And we should strive towards excellence in all spheres of undivided and collective activity, but also include the protection of environment also. Okay, cool. T. Damodar Rao versus S.O. Municipal Corporation, Hyderabad. It was in this case that, in the view of Article 48A and 51AG, it is evident that the protection of environment is not only the duty of citizens, but it is also the obligation of the state and all other state organs, including the courts. 48A was. What was 48A? 48 was Milch. 48A was. Let's go back. Oh, the most important thing. The state shall endeavor to protect and improve the environment. State shall endeavor to protect and improve the environment. So it is not only the job of the people, not only the duty of the citizen, but also the state. 48A and 51AG. So it kind of reiterated the statements made under 48A and 51AG. 48A being the directive principle wherein citizens, and in which the state is directed that it should take care of the protection of environment, but also the fundamental duty of the citizens to take care of the protection of environment. Acha, acha, acha. Okay, this makes sense. Now see, like 51AG is a fundamental duty. So we have a duty to protect the environment. But when it comes to directive principles, the states are not obliged. But this okay, so this is a very important case. This case made it a point that states do not shy away from their duty. State is also made an equally important aspect when it comes to the protection of environment. See, not only the duty of the citizens, but it is also the obligation of the state. So it is also the duty of the state and all of the state organs, including the courts, to protect the environment. T. Damodar Rao versus SO Municipal Corporation, Hyderabad. T. Damodar Rao versus SO Municipal Corporation, SO Municipal Corporation, Hyderabad. Important. Next, Sachidanand versus State of West Bengal. There is a missing here. I'm pretty sure it is Sachidanand. Okay. It has been observed in this case that in cases where the problem of ecology is brought before the court is bound to bear in mind Article 48A, which enjoins that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. So this is also important, and it is somewhere very similar to T. Damodar Rao versus SO Municipal Corporation, Hyderabad. Here also it is stated that when the court is brought with a case with a problem of ecology, then the court should bear in mind Article 48A, where the state shall endeavor to protect and improve the environment and safeguard the forest and wildlife of the country, as if it was their obligation as well, like a fundamental duty of the state, something like that. Right. Moving on, fundamental rights for protection and preservation of environment. Principle 1 of the Stockholm Declaration 1972 says, every person has fundamental right to an environment of quality that permits life, dignity, and well-being, and has solemn responsibility to protect and improve the environment for present and future generations. So the first principle 1 of Stockholm Declaration says that every person has fundamental right to an environment of quality. Okay, so every person has a fundamental right to an environment of quality. Every person has a fundamental right to an environment of quality that permits life, dignity, and well-being, and has solemn responsibility to protect and improve the environment for present as well as for future generations. Fundamental rights are those rights which have their source and are explicitly or implicitly guaranteed. Fundamental rights are regarded as fundamental because they are most essential for the attainment by the individual or his full intellectual, moral, and spiritual status. Most essential, fundamental rights are fundamental because they are the most essential for the attainment by the individual or his full intellectual, moral, or spiritual status. Article 21. Okay, so fundamental rights for protection and preservation of environment. Article 21. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. In rural litigations and entitlement Kendra, Dehradun versus State of Uttar Pradesh, popularly known as the Dehradun quarrying case. Rural litigation and entitlement Kendra, Dehradun versus State of Uttar Pradesh. popularly known as the Dehradun quarrying case. In July 1983, representatives of the Rural Litigation and Entitlement Kendra Dehradun wrote to the Supreme Court alleging that illegal limestone mining in the Mussoorie Dehradun region was devastating the fragile ecosystem in the area. So on 14 July, the court directed its registry to treated the letter as writ petition under Article 32 of the Constitution. So illegal limestone mining in Mussoorie region, and it was destroying the fragile ecosystem. So they wrote a letter to the Supreme Court. Oh, the Rural Litigation and Entitlement Kendra Dehradun wrote a letter to the Supreme Court. The Supreme Court treated the letter as a writ petition and served and with notice to government of Uttar Pradesh and collector of Dehradun. Over the years, litigation grew increasingly complex. By the time the court issued its final judgment in August 1988, wow, the amount of time. It had heard lengthy arguments from central and state government agencies and mine lessee, and appointed several expert committees and passed 5 comprehensive interim orders. But none of these orders articulate fundamental right to a healthful environment. Under Part 3 of the Constitution, following articles provide for specific provisions for environment protection. But none of these orders articulate fundamental right to a healthful environment. Then why the hell are we reading this? What? Okay, don't go to this particular aspect. Think about it in a different sense. As a result of the letter, I can say that this quarrying would have stopped. If it weren't, then there's no point in even writing the thing. Wait a minute. What am I doing? Dehradun quarrying case. So it says Tools of the economy, most vital judicial interpretation, countering governmental policy powers under the Dehradun Valley litigation, major rulings of the case. Yes, the court prohibited blasting operations while it was reviewing to determine whether the mines were being operated in compliance with the safety standards as laid down in Mines Act. Okay, so the blasting and all, it stopped because of the letter, and I don't know if it was because the court felt if there was a need, whether there was a need, whether the ecosystem was actually being destroyed. But the thing is, because of the letter, the quarrying stopped and the fragile ecosystem sustained. That's it. Moving on. Under Part 3 of the Constitution, following articles provide for specific provisions for environment protection. Article 15, Clause 2, Clause B, Subclause B. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subjected to any disability, liability, restriction, or condition with regard to use of wells, tanks, bathing ghats, and places of public resort, maintained wholly or partly out of state funds or dedicated to the general public. So, all of this thing. In simple words, this article prohibits discrimination on the ground of sex, race, religion, caste, place of birth, etc., maintained by the states. Prohibition of discrimination. Article 15, Clause 2, Subclause B. shall be deprived of his life and personal liberty, and here no discrimination or dedicated to the general public. The public places which are part and parcel of the human environment should be made available to public. The preamble of our constitution ensures socialistic pattern of the society and decent standard of life. Wow, me mispronunciation. That's good. The preamble of our constitution ensures socialistic pattern of the society and decent standard of life, which can be possible in a pollution-free environment. Indian Council for Enviro Legal Action versus Union of India. CRZ notification case. In this case, Supreme Court observed that environmental statutes were enacted to ensure a good quality of life for unborn generations, since it is they who must bear the brunt of ecological degradation. Brunt. I'm pretty sure what it means, but just check. The worst part or chief impact of a specified action. So in this case, the Supreme Court observed that environmental statutes were enacted to ensure a good quality of life for unborn generation. Ensure a good quality of life for environmental statutes were enacted to ensure a good quality of life to unborn generations, since they are the ones who will have to face the major brunt of the ecological degradation. Nice word, brunt. So Indian Council for Enviro Legal Action versus Union of India. Next, Sushila Sawmill versus State of Orissa. In this case, Section 4 of Orissa Sawmills and Saw Pits of 1991, which prohibited Control Act. Okay, in this case, Section 4 of Orissa Sawmills and Saw Pits Control Act of 1991 prohibited sawmills from operating in a forest or within a buffer of 10 kilometers from the forest. The constitutional validity of this order was challenged. Court held that in the interest of general public, restriction under Article 19 may include total prohibition. God, I didn't understand, I'm not doing it. Subhash Kumar versus State of Bihar. In this case, court held that right to life includes the right to enjoy unpolluted air and water. This is a good case. Subhash Kumar versus State of Bihar. In this case, court held that right to life includes right to enjoy unpolluted air and water. Right to life includes right to enjoy unpolluted air and water. If anything endangers or impairs the quality of life in derogation of law, a citizen has right to move Supreme Court under Article 32 of the Constitution, expanding upon this theme in town planning case. Okay, so if anything endangers or impairs the quality of life in derogation of law, a citizen has the right to move the Supreme Court under Article 32 of the Constitution, expanding upon this theme in town planning case. What is the town planning case about? Town planning case. Okay, so no specific case law as such which emerges straight out of the box. There's this Indian Kanun here, but I don't know if it is this. No, better not to delve into this thing now. Anyway, so basically the most important thing, however, is that right to life includes right to enjoy unpolluted air and water. Right to life includes the right to enjoy unpolluted air and water. So if there's anything which endangers or impairs the quality of life in derogation of law, then a citizen has a right to move the Supreme Court under Article 32 of the Constitution. Okay. Don't give importance to this particular aspect. Article 32 of the Constitution. The citizen has a right to bring the matter before the Supreme Court or the High Court, expanding upon this theme in Article 32 of the Constitution. Right to move Supreme Court under Article 32 of the Constitution. If there is if right to life, if there is an endangering or impairing of the quality of life, because his right to enjoy unpolluted air and water is being questioned, is being put to test or something. Okay, so that is Subhash Kumar versus State of Bihar, very important. Moving on, absolute liability. Absolute liability is like a principle, okay? Like a person who does something wrong becomes, a person or an organization who does something wrong becomes absolutely liable or something. That's what I can make out on the basis of the topic. Okay, so the principle of absolute liability in accident cases arising out from activities involving hazardous substances have been laid down by the Apex Court in, again, MC Mehta versus Union of India, which is popularly known as the Oleum gas leak case. Oleum gas leak case 1987. MC Mehta versus Union of India. In this case, Supreme Court has observed that an enterprise or industry which is engaged in a hazardous or inherently dangerous industry which pose a potential threat to the health and safety of persons working in the factory and residing in the surrounding areas owes as absolute duty to the community to ensure that no harm results to anyone on account of such activity. If any harm results on account of such activity, the enterprise must be absolutely liable to compensate for such harms, and it should be no answer to the enterprise to say that it had taken all reasonable care and that the harm occurred without any negligence on its part. In this case, the Supreme Court has held that everyone has right to protection against exposure to hazardous substances. Right to protection against exposure to hazardous substances. Okay, so it's an important thing. So in this case, the Supreme Court has observed which is engaged in hazardous or inherently which pose a potential threat to the health and safety of persons working in factory and residing in the surrounding areas owes an absolute duty to the community that no harm results to anyone on account of such activity. So if such a industry is operating near near the surroundings where there are people residing, where there are surroundings where people are residing, and also the persons who are working in the factory. So the persons working in the factory and residing in the surrounding area, to them the industry which deals with hazardous substances has an absolute duty to ensure, to tell them that, no, to ensure that their activity will not cause any harm to anyone, So, and if any harm occurs, then the enterprise will be absolutely liable to pay the compensation, and there will be no escape. There will be no atonement to their sin, even if they say that they had taken all reasonable care so that the harm is averted. So in this case, the Supreme Court has held that everyone has right to protection against exposure Right to protection against exposure from harmful or hazardous substances. Right to protection against exposure to hazardous substances. Okay, moving on. Damages caused to individuals, property, and the environment by industries have posed a challenge for the legal system in India at least since the Bhopal gas incident in 1984. The risks posed by industries to human beings have been a matter of concern for long. However, the manner in which these risks have been addressed under law, most importantly, the liability of industry has undergone drastic changes. The issue of liability of industries for causing injury to the environment and people received a dramatic push after Bhopal gas disaster, which demonstrated the potential of industries to cause severe damage to environment and people on a large scale with continuing effect for decades. The 1980s further witnessed other industrial accidents such as 1980s further witnessed Bhopal gas tragedy occurs in the year 1984. There are in 1980 another oleum gas leak incident occurs in the year 1985. That's just 1 year after Bhopal gas incident. Mm. Further witnessed other industrial accidents such as oleum gas leak incident in Delhi in 1985. So these industrial accidents together with similar incidents in other parts of the world led to the development of a legal framework addressing the liability of industries in cases of industrial accidents. Industrialization and the growth of chemical and other hazardous industries triggered the development of new jurisprudence in the context of industrial accidents. Industrial accidents like the Bhopal gas leak further contributed to the momentum. In 1985, while hearing the case concerning the leakage of oleum gas from an industry in Delhi, in MC Mehta versus Union of India, the Supreme Court evolved a new principle called the principle of absolute liability. The Supreme Court felt the need to evolve new jurisprudence to keep up with a developing and highly industrialized economy. It was held that the enterprise must be held to be under an obligation to provide that the hazardous or inherently dangerous activity in which it is engaged must be conducted with the highest standards of safety, and if any harm results on account of such activity, the enterprise must be absolutely liable. Wait, so what the Supreme Court observed was that it there where in the cases of where in the cases of enterprises which deals with hazardous or inherently dangerous activity, the highest standards of safety must be taken into consideration, and in case any harm is caused, then the enterprise must be absolutely liable to pay compensation for such harm, and it should be no answer to say that it had taken all reasonable care and the harm occurred without any negligence on its part. So, in the oleum gas leak case, the Supreme Court removed all exceptions applicable to the rule of strict liability and took the principle of absolute liability in the context of inherently hazardous industries to a different level. The court has applied the rule of absolute liability in subsequent cases. So earlier, before the absolute liability principle, strict liability uh, was the aspect which the courts followed, especially in the Bhopal gas tragedy. That's the reason why that MF um, escaped. Okay, strict liability. Wait a minute. He was lucky guy. Strict liability is the imposition of liability on a party without a finding of a fault, such as negligence or tortious intent. The claimant need only prove that the tort occurred and that the defendant was responsible. The law imputes strict liability to situation it considers to be inherently dangerous. In criminal strict liability is a standard of liability under which a person is legally responsible for consequences flowing from an activity, even in the absence of fault or crime or criminal intent on the part of the defendant. Mm, let's type strict liability and absolute liability difference. A person could be guilty even if there was no intention to commit a crime. The difference between strict and absolute liability is whether the defense of a mistake of fact is available. In a crime of absolute liability, a mistake of fact is not a defense. Let's see what Wikipedia has to offer. Not only have committed a criminal action but also have had a deliberate intention or guilty mind. In a crime of strict or absolute liability, a person could be guilty even if there was no intention to commit a crime. The difference between strict and absolute liability is whether the defense of a mistake of fact is available. In a crime of absolute liability, a mistake of fact is not a defense. Strict or absolute liability can also arise from inherently dangerous activities or defective products that are likely to result in a harm to another, regardless of protection taken. Such as owning a pet rattlesnake, negligence is not required to be proven. Hmm. Can also arise from inherently dangerous activities or defective products that are likely to result in a harm to another. What do you think? Absolute liability is a standard of tort liability. Indian judiciary right to make a strong Bhopal gas tragedy to enforce greater amount of protection. Okay, so if there is a defense of mistake of fact available or not, that is the thing that differentiate strict liability from absolute liability. So if there is a defense of mistake of fact available, then a person need not be made responsible. Okay. Anyway, that defense itself is taken away when it comes to absolute liability. So even if you do not, even if you claim that there is a defense of mistake of fact, then you cannot be, then even then you will be, oh, even then you will be made liable. Whether the defense of a mistake of fact is available. Mistake of fact is not a defense. Wow, in a crime of absolute liability, a mistake of fact is not a defense. So even if there is a mistake of fact, you'd still be liable. Okay. In 1995, this rule was applied in Consumer Education and Research Center versus Union of India. So now we do understand what absolute liability is. God, it's dangerous. Okay, so in 1995, this rule was applied. So absolute liability and all came into being in the oleum gas leak case, and they're like, as it is our inherently dangerous activity, highest standard of safety must be taken care of, and if any harm occurs, then the enterprise will be absolutely liable. There is no atonement for whatever they have done, and they need to pay compensation for their act. In 1995, this rule was applied in Consumer Education and Research Center versus Union of India. Year 1995, as in where asbestos mine workers were exposed to extreme health hazards. The Supreme Court held that even if the mine were not at fault by bringing their workers in contact with hazardous substance, they were liable. The court ordered many asbestos mines and industries to pay compensation to workers who had contracted asbestosis. So that was the thing. The case was Consumer Education and Research Center. Consumer Education and Research Center versus Union of India. Consumer Education and Research Center versus Union of India. Consumer Education and Research Center versus Union of India, where asbestos mine workers were exposed, even if the mine itself were not responsible for bringing the workers in contact with the hazardous substances, they were still liable. And the court ordered many asbestos mines and industries to pay compensation to the workers. Consumer Education Research Center versus Union of India. So this principle was applied again in 1996 in Indian Council for Enviro-Legal Action versus Union of India. We did this case before. When the Supreme Court heard a case involving environmental pollution caused by chemical industries in Bichri village in Rajasthan. So when the Supreme Court heard a case involving the environmental pollution caused by chemical industries in Bichri village, the same principle was applied. Enviro-Legal Action versus Union of India. Indian Council, the court found that industries had violated environmental standards in dealing with sludge and other toxic discharges. Right, okay. Fine. Move on. The Supreme Court reiterated that the English rule of strict liability was inadequate for Indian conditions. So the English rule of strict liability was inadequate for the Indian conditions, and that absolute liability with no exception was the rule applicable in this case. So absolute liability is the only way we can take care of the condition here in India. Another important principle evolved by the Supreme Court in this regard is the deep pocket theory. Deep pocket theory. Again, MC Mehta versus Union of India. This is again the oleum gas leak case. MC Mehta versus Union of India, deep pocket theory. Man, this guy, MC Mehta, is a boss. I mean, what would be the right adjective for Mr. MC Mehta? Relentless in the field of environmental law. Okay, deep pocket theory. He was the reason why there is like two principles now. This is deep pocket theory is one theory that was developed, and there's also absolute liability theory, absolute liability principle. So one principle and also a theory. Wow, good. Deep pocket theory developed in MC Mehta versus Union of India. According to this theory, the amount of damages payable by an enterprise should be correlated to the magnitude and capacity of the enterprise, because such compensation must have deterrent effect. It should be able to scare the industry. So it should correlate to the damages should correlate to the magnitude and capacity of the enterprise. Damages payable by an enterprise should be correlating with the magnitude and the capacity of the enterprise. Okay, the larger and more prosperous the enterprise, greater must be the amount of compensation payable by it for the harm caused on account of an accident in the carrying on of the hazardous or inherently dangerous activity by the enterprise. So the scope of absolute liability. Absolute liability doesn't carry any exception. It has a wide scope. So it does not carry any exception, and it has a very wide scope. That's what the scope of absolute liability is like. Right. Oh, we have reached the 100 slides mark. We could cover 70 slides in 2 hours. So most probably in the next 3 hours we should be able to finish the whole thing. Should I stop here? I think I should. I'll stop here. It's almost an hour, and we'll proceed with another part.